wait until October 29th to hear that.
We would request that you advance that hearing today, Your Honor, and hear that pursuant to the local rules.
Your Honor, the state does not object to advancing or granting that motion.
Okay. And the court had already had an opportunity in anticipation of what was going to be necessary for today, so the court had already had an opportunity to look at the motion to seal and redact that's currently set for October 29th. And the court advances it to today at the request and non-opposition of the parties, EDCR 2.23, and grants it under EDCR 2.20, being fully cognizant of Supreme Court Rule 3, which the court independently evaluated, as well as applicable case law. Okay, so now let's go to your other motion. We have Meta Platforms Inc.'s motion to dismiss, and I'm just going to say messenger case because that's the way you all have asked to phrase these as three separate cases, and that would be document 210, and the redacted version was 212, appendices 211, redacted version 213, and it was well timely done, and then have the opposition there too, documents 209, and we have the reply therefore as well. So, by agreement of the parties, was there a specific allocation of time for your motion or not? I know you all have a special setting. I know you all talked about different timings and a variety of the different communications. And so, let me hear, please, what's your most updated version of what you'd like?
Well, Your Honor, Michael Gayan for the state. It's Meta's motion, but to my knowledge, there hasn't been any specific discussions about order of argument or allocation of time or anything like that. I know there was some uncertainty on the court's availability today until recently when your trial stack kind of went away, is my understanding. But so we're open.
The case set for trial today went away, not my whole trial stack.
Yes. Okay, so your 5-week stack is not empty. Okay, I misspoke. But yes, today's starting date maybe is more open. That said, I don't know that we need to take more of the court's time than necessary, but it is Meta's motion, so we're talking about it.
I mean, Your Honor, we would be guided by what would be helpful to the court. We were envisioning probably 30 to 45 minutes to argue our side of it.
Okay, so I give Meta 45 since you get last word, and I give the state 30. Is that a good ballpark, not including questions, or do you all think that you need more time than that? I don't know. You all have already ballparked your own presentations. I don't know what's necessarily coming my way as far as if there's going to be PowerPoints, if there's already a lot of different things, and so does that meet your needs, or does somebody need something different?
It works for us, Your Honor.
Your Honor, for the state, I believe that works. I would just ask for a little leeway if I need a bit more than 30 minutes, but I believe I can be efficient with the court's time.
No worries, that's fine. I'm just trying, like I said, I do have a little bit more flexibility today because the trial that was supposed to commence today resolved, and so we've got a little bit more time for you, but we want to make sure, obviously, that every case gets handled. As some of you are aware, this court this week has a variety of very large cases that it is addressing, and thousands and thousands of pages, including ones involving some of the counsel for the state later this week. So, okay, then counsels, you should feel free. Do you want to use? You can use counsel table. You can use the podium. You can use the small podium. Whatever you'd like. Feel free to go ahead. And do you need any of the technology?
No, Your Honor, I wasn't planning on any high tech today.
Okay, no worries.
Thank you, Your Honor. Timothy Hester again for the Meta defendants. I am going to cover 3 particular points: personal jurisdiction, First Amendment, and Section 230. And since we're covering a lot of real estate today, if it's agreeable to the court, we're planning to have Ms. Peterson cover the Deceptive Trade Practices Act claim, and to have Mr. Sneed cover the balance of the claims that we address in our motion, if that's agreeable to the court.
Standard practice is we check with the other side, right, just to see what their position is because of the fact that it was filed as one motion, right, and dividing up part of state. Do you have any objection?
Your Honor, for the state, Michael Gayan, I will have to object. I mean, if they had reached out to us ahead of time, we maybe could have discussed this, and others on my team could have prepared and divided. There are a number of issues. It's a significant motion. I'm prepared to argue the entire motion because of the local practice and that Your Honor just cited. So I guess I will make the objection on behalf of the state because of the lack of advance notice until we're standing here ready to commence.
Okay, so let me let you respond. Have you all prepared it so that,
We hadn't prepared it that way. We've certainly split up other arguments previously. We haven't had practice in this case of having one lawyer argue all the issues. We had assumed that this would be agreeable. We hadn't really thought this was controversial.
okay, well, here's, as you know, the general local practice, right, is raises the one horse, one rider. However, realistically, in this case, you all have been very cooperative and let different people bring in different things at different times, and I don't find that it would be appropriate to change that for today. In the future, please make sure you all communicate with each other so that everyone has a full opportunity to prepare how they wish to prepare. But realistically, with the various times that you all have been here, I don't see that there is any prejudice to the state by having different people argue as long as you're contained within a reasonable time frame. Okay, that's what Mr. Gayan. Are you standing up because you wanted to say something, counsel?
I am, Your Honor, Michael Gayan for the state. I would just ask for leeway if Mr. Slade or maybe somebody else on my team wants to make comments on a discrete issue. I would ask for some leeway since I'm 3-on-1 today. But I don't believe that will be, I don't anticipate that'll be necessary. But Mr. Slade is a subject matter expert on some of these legal issues, has litigated them many times in other jurisdictions. And so I would just ask for some leeway on that.
I am sure defense counsel is going to say fair is fair, right?
We certainly don't have an objection to that, Your Honor.
Didn't think so. Okay, so we can do that, just as you all know, one person speaking at a time, so we'll get you a nice clear record. Okay. Counsel,
Thank you, Your Honor.
you're taking
So I'm
First
going to,
Amendment and 230, right?
yes, personal jurisdiction, First Amendment, and then Section 230 are the 3 points I was going to cover. So let me first begin with the personal jurisdiction issue, which we submit is should be the basis for dismissing the complaint in its entirety. And I want to focus in particular on the arising out of or relating to prong of the personal jurisdiction standard. Just to set the table, the state is not arguing general jurisdiction. Its opposition makes that clear, that it's only arguing specific personal jurisdiction. And the key issue for personal jurisdiction here, the dispositive issue, is whether the claims arise out of or relate to Meta's contacts with Nevada. The state's argument in its brief does not really address this prong for personal jurisdiction. At page 16 of its brief, the state says, quote, because Meta has purposely availed itself of the laws and market of Nevada, the state's claims arise from Meta's conduct. That's page 16 of the brief. That is a legal error. Purposeful availment does not establish that claims arise out of or relate to the contacts with the forum. They're two separate issues, as the court is well aware. And Tricarici makes this clear. The court in that case said, quote, claims must have a specific and direct relationship or be intimately related to the forum contacts. That's 135 Nevada at 94. And the court specifically distinguished cases, finding that defendants' activities with the forum gave rise to the plaintiff's claims. And in Tricarici, the court said they did not arise from the contacts with Nevada. And we also see in the Trump decision that we've cited in our briefs, the court said that the cause of action must arise from, quote, conduct targeting the forum. That is the test. That's 109 Nevada at 699. Now, the court previously asked us in prior arguments on personal jurisdiction whether this means that the Attorney General cannot enforce its consumer protection laws in the local courts here. And I would say, first of all, that depends on the nature of the claim. Some consumer protection claims may well arise out of a company's contacts with Nevada. As an example, In this case, the state alleges that Meta was involved with the high school education curriculum. If the state were to bring an unfair practices claim based on that program, that would be something that arises out of or relates to those contacts with the forum. So it depends on the nature of the claim. I would also add that we certainly see that attorneys general often sue in other states to enforce their laws. And in this particular situation, 34 other attorneys general have sued Meta in the Northern District of California on essentially the same legal theories that are advanced here. So the inability to sue in the local court doesn't defeat the ability of the Attorney General to vindicate the rights of Nevada consumers and residents. It only affects where the question of where the claims can be litigated. So personal jurisdiction doesn't preclude the Attorney General from enforcing its law. It just affects where the claims can be litigated. And of course, as the court well knows, convenience to the plaintiff is not a consideration in the personal jurisdiction analysis. The due process limits on personal jurisdiction are meant to protect the defendant from suits all over the country if the claims don't arise out of or relate to its contacts with the forum. So let's turn to the state's claims in this case. They do not arise from Meta's alleged Nevada contacts. The state alleges targeted advertising by Nevada businesses on Messenger. That has nothing to do with the claims of alleged addictive design features or misrepresentations about the safety of Messenger. Generating ad revenue is not a basis for the AG's claims here. And if motivation or incentive, in other words, if the suggestion were, well, you're motivated to have users in the state, if motivation or incentive were enough, that would override the test for arising out of or relating to. I would make the same point about user contracts, which the state alleges, that there are terms of use entered into by Nevada residents, but that again is not the basis for the claims being asserted here. The state also raises a number of other contacts, attendance at trade shows, lobbying activities, mobile phone carriers. All of these are completely unrelated to the claims. So to sum up, the case law requires a direct connection between the forum activities and the claims. Tricarici says the test is whether the forum activities, quote, give rise to the claims, or, quote, have a specific and direct relationship to the claims. Or the Trump case, the claims have to, quote, arise from conduct targeting the forum, and the claims here don't. So that is the basis on which personal jurisdiction is most readily resolved and the most clear and straightforward basis to conclude there is no personal jurisdiction here. The court doesn't even need to reach the separate question of purposeful availment because the state cannot establish the claims arise out of or relate to Meta's contacts with the state. The arising out of or relating to standard is more straightforward here, and it's a clear reason why there's no personal jurisdiction. But the state also can't establish purposeful availment. First of all, the state relies on the effects test. But in the Paul D. Bergauer case, the Nevada Supreme Court said, quote, we conclude that the effects test applies so long as the underlying claims sound in intentional tort. That's 521p3 at 1162. The effects test simply doesn't apply. The claims here don't sound in intentional tort. There is no allegation of an intentional tort by the state here. So we're not in the effects bucket. That part of personal jurisdiction on purposeful availment doesn't apply. So then we turn to the minimum context test for purposeful availment. That requires some specific targeting of the forum state. And again, in Tricarici, we see the language, whether the conduct is, quote, expressly aimed at Nevada. Now, I should mention to the court that we quoted the Ninth Circuit decision in Briskin for this proposition in our opening brief. That case was since vacated. but there are numerous other cases that say the same thing, including the AMA multimedia case, which we cited in our briefs out of the Ninth Circuit, which says that the conduct has to be, quote, expressly aimed at the forum. Some particular focus on the forum, some particular targeting of the forum is what is contemplated for purposeful availment. And this requires some targeting that goes beyond the simple availability of internet services. It can't be established simply where users, residents of Nevada, or businesses located here make their own decisions to sign up for Meta's services. Again, Triferici tells us that. It says specific personal jurisdiction, quote, must focus on conduct the defendant purposely directs at the forum state, not decisions by residents to sign up for the service or advertisers to sign up for the service. And for this reason, purposeful availment is not established by advertising activity in the state or by a user base in the state. Those are decisions made by others to sign up for the service. And that is a core point I wanted to stress. A user base in a given state or advertising by businesses does not show targeting of Nevada by Meta. It shows simply that Messenger is universally available all across the country with no specific targeting or differentiation of Nevada as compared to any other state. And that makes complete sense. Decisions by third parties in a state to use the services of a nationwide or an international internet service don't reflect purposeful availment by the social media service itself. And it requires something more than that for purposeful availment. And otherwise, global media, social media services would be subject to jurisdiction everywhere. And that's a result that the case law rejects. And the state in particular here has gone through, I think, almost 6 months of jurisdictional discovery. And it's come up with no evidence of targeting of Nevada by Messenger. And that's quite notable in their brief. You do not see the evidence presented of purposeful availment, some specific targeting of Nevada. And to the contrary, the evidence demonstrates that Meta did not target Nevada. In our reply brief at page 12, we quoted the 30B6 witness who testified on these issues, and he said, quote, our strategy has been to focus on the United States as a whole. And he's, quote, we did not focus on states and cities. We did a major focus on the United States as a whole. So the state can't establish purposeful availment because it does not have evidence of specific targeting of Nevada. But again, I would underscore the court doesn't even need to reach that issue because the arising out of or relating to prong for personal jurisdiction is not satisfied, and that defeats personal jurisdiction as a matter of law, whether or not the state can separately establish purposeful availment. Maybe I would pause there, Your Honor, before I move on to my next topic and see if the court has any questions.
I'm going to wait to see what the state's response is to some of those issues rather than asking directly on some of those. So
Thank
I
you,
do
Your Honor.
not thank you.
Okay, so let me now turn to the First Amendment points. And I wanted to come to the First Amendment before Section 230 for an important reason. There was a major change and major development in the law since we filed our motion to dismiss in March that bears critically on the First Amendment question. And that is the Moody v. Net Choice decision out of the Supreme Court issued in early July, where the court said, quote, expressive activity includes presenting a curated compilation of speech originally created by others. That was a general principle that the court referred to. But then it said something very important about social media services in particular. And I'm quoting now from 144 Supreme Court at 2405. The court said, the major social media platforms are in the business when curating their feeds of combining multifarious voices to create a distinctive offering that in the aggregate give the feed a particular expressive quality. That's a key point, an expressive quality from the compilation of speech by social media services. And then the court went on to say at 144 Supreme Court at 2406, because social media services, quote, decide which third-party content those feeds will display or how the display will be ordered and organized, they are making expressive choices and receive First Amendment protection. So why is that so crucial? Because the Supreme Court specifically reached out to address the scope of First Amendment protection for social media services, articulated a standard that recognizes First Amendment protection is not simply limited to the content they publish, but to the decisions they make about how they're going to display and organize content. And that's exactly what the state is challenging here. The expressive activity of Meta itself in deciding how to organize and display the content that's on its services. The state misses the point when it says it's not challenging content. Because Meta's editorial discretion and decisions about how to compile and present third-party content, that's what the state is calling conduct, is protected by the First Amendment. Net Choice tells us that. It says organizing and presenting third-party content is, quote, expressive activity. And in particular, that expressive activity includes presenting a curated compilation of speech. That's what Messenger is doing, presenting a curated compilation of speech. Now, I know the court has previously raised the question, is this commercial speech? And I would submit clear it's not. Commercial speech is, quote, and I'm quoting now from the Bolger v. Young's drug production case. Commercial speech is, quote, speech which does no more than propose a commercial transaction. Propose a commercial transaction would be the test for commercial speech. That clearly doesn't apply to what Messenger is doing. As the court well knows, it's not commercial speech simply because it's made by a corporation. It has to be speech that's proposing a commercial transaction. That's not what's happening here. What Meta is doing, what Messenger is doing, is engaging in the expressive activity that Moody recognized, expressive activity about how it's going to organize and display content. And there's certainly no suggestion in the Moody case itself that that's a commercial speech issue. And to the contrary, the court underscored that there is this important First Amendment right that's available to social media services for their own decisions about how they're going to display content, which is exactly what the state is challenging here. So that gets me through First Amendment, and I think the court wants to.
I actually do have a question on this one. Okay. And I just need important clarity. Because sometimes through your presentation, it's Meta, and sometimes your presentation, it's Messenger, right? Now, this court has consolidated all three cases, as you all requested, but you specifically asked this court to only address Messenger for purposes of today's hearing and for other potential other purposes, right? So the organize and compilation with regards to Messenger, fully get what you're saying, you're using Meta, right, as the umbrella. But when you're talking just Messenger, how would that apply to Messenger, given the nature of what you all have had, you at least agree on what the Messenger service is for this court to evaluate,
Yes.
right? So,
And the court has asked a very good question, and there may have been some imprecision. When I was speaking of Meta in this context, I was speaking of Meta in relation to its activities on Messenger. And so let's look at some of the activities that are alleged in the complaint that Messenger is engaged in. Endless scroll, paragraph 121 of the complaint, where, quote, a user is continuously fed more pieces of content. Autoplay, paragraph 125, continuously playing video content. Notifications, paragraph 128, notifications and pop-ups to alert the user to new messages. Likes, paragraph 134 of the complaint, the number of interactions that content has received. Ephemeral content, paragraph 144, making certain content ephemeral. So I would suggest all of those fall in this category that Moody recognized. Those are decisions by Meta through Messenger about its expressive activity, how it is going to organize and display content. It's ordering and displaying content in a certain way. It's making an expressive judgment about how it is going to make content available. And the Moody case recognizes a First Amendment protection for that.
And the end-to-end encryption issue, particularly as it involves minors. I didn't
Your
hear
Honor,
that specifically addressed. If you wouldn't mind, please.
I would say the end-to-end encryption is likely more in the realm of section 230, which I'd like to turn to next. But yes, I would say it would be harder to say that there's an expressive element of end-to-end encryption standing alone. But it does also fit in this concept of decisions about how to order and organize and display content. And that's the expressive activity recognized in Moody. I think it applies more obviously, more easily to things like ephemeral content, of Meta's through Messenger making a decision about how certain content will be made available. That's a decision they're making about their own service that they want to provide to their users. And the Supreme Court, I think, really reached out in Moody to underscore that there is protection for social media services when they're doing this. But I think the court's question is a good one. End-to-end encryption maybe fits more squarely in the section 230 analysis. Does the court have other questions on First Amendment, or should I turn over to 230?
Feel free to go to 230.
Okay. So as the court well knows, the state's claims are based on allegedly addictive or harmful design features. And those are barred by section 230 of the Communications Decency Act. In the state's argument, the core response the state makes is that it's not challenging content, but rather conduct by Meta. But I submit, Your Honor, that that is a false distinction. Section 230 applies not only to content itself, but also to decisions about how to publish content, what is referred to as publishing activity. Section 230 is not limited simply to the content itself. It applies to publishing activity, and we see this stated well by the MDL court, which is overseeing these cases in the Northern District of California. Section 230, quote, extends to editorial decisions and functions ancillary to the decision to make content available. And Force v. Facebook says the same thing. Section 230 protects, quote, features that are part and parcel of the overall design and operation of the website. Of course, Section 230 provides immunity for harm from content, but it's not limited to that. It also extends to publishing activity. And here, the state's claims are challenging publishing activity by Messenger, the design features by which it publishes content. And the case law recognizes that publishing activity includes activities, tools that are meant to facilitate the communication and content of others. The tools themselves are within the scope of Section 230's protection for publishing activity. And I think the distinction is well illustrated by the Lemon case, and I know the court's familiar with that case. The feature at issue there was not being used to publish content. The feature at issue there was a speed filter. It was really like a stopwatch you could have on your phone. It's completely different from a feature that is being used as publishing activity, such as a notification or an endless scroll, a decision that how content is going to be published. That is different from what was at issue in the Lemon case. And that, in particular, I would point the court to Lemon itself, 995 F. 3rd at 1092, where the Ninth Circuit said plaintiff, quote, does not seek to hold Snap liable for its conduct as a publisher, But that's notable in a couple of respects. One is, it was really like a stopwatch or a timer on your phone. It's not the same as publishing, and I think the Ninth Circuit recognized that. But also, Lemon itself calls out that Section 230 would apply to conduct as a publisher. Conduct as a publisher would be within the scope of 230, but Lemon said that wasn't the issue in that case. So I think we can see in Lemon itself that there is this recognition that 230 is not confined merely to the content itself. The other case I wanted to speak to is the Dyroff case, where the alleged harm to the user was from exposure to third-party content, no question about that. But the reason that the publisher, that the social media service was immune was that the lawsuit challenged publishing activity. So the Section 230 immunity for the social media service did not depend on the nature of the harm. It depended on the fact that the social media service was engaged in publishing activity. That was why it had a Section 230 immunity. It wasn't because of a certain kind of harm. And in that case, the issue was algorithms that matched the content to users' interests. And the court recognized that these were tools meant to facilitate communication of others. And so it was publishing activity, and that was why the social media service had its own immunity under Section 230 for that claim, and why it was able to avoid tort liability because Section 230 extends to that kind of publishing activity. Now, I went through already for the court the allegations in the complaint that I think make clear that what the state is challenging here does involve messengers' conduct in publishing content. And we see that in relation to endless scroll, autoplay, notifications, likes, ephemeral content. These are all things that the state is challenging where Meta is engaged in publishing activity. These are the tools that facilitate communication with others. So this is separate and apart from the First Amendment issue. This is the reason that the claims are barred. Now, maybe I can speak briefly about end-to-end encryption in particular. Encryption of messages is a form of publishing. That's clearly recognized that this is publishing activity, and it's a decision about how content is going to be published. So it falls, I think, classically within the scope of Section 230 because it's a judgment being made by the social media service about how it is going to publish content to its users. Here, it's making a decision to publish using encryption. That falls squarely within this concept of publishing activity that's immune under Section 230. Unless the court asks questions,
I
I
might
can
do it on
stop
the
there.
last sentence you said, if you don't mind. You said it's publishing activity to determine to use encryption. Can you explain a little bit more what
Yes.
you mean by that?
It's a judgment about how the information is going to be made available. It's is the information made available in a form that's encrypted, or is it made unencrypted? And but it is inherently publishing of content. It is, I am going to publish this content with encryption. So it's a form of publishing activity.
Walk me through a hypothetical that does not invade your sealed information and confidential, right? So walk through. If, and I appreciate there's a different viewpoint whether or not you have minors on the platform or not, but okay, person A and person B, right, are engaging in communications. So can you walk through how you're asserting that that falls within a 230 aspect? And once again, I'm focusing on the encryption. Go ahead, please.
I would go back to the Dyroff case from the Ninth Circuit. And the language out of Dyroff is, quote, tools meant to facilitate the communication and content of others. That's the test that Dyroff articulated. for the scope of Section 230 immunity. And these are tools that facilitate communication between people, and the court heard quite a bit of evidence about why end-to-end encryption is important to people who are engaged in the communication. So I think it would be bedrock publishing activity in that sense, because you have a decision, how am I going to facilitate the communication between person A and person B? I'm going to facilitate it with encryption that allows them to have confidence that their communications are secure. So that's a decision being made by the social media service that facilitates and allows users to communicate with each other through Messenger in a way that protects the security and privacy of their messages. So I think it fits very squarely within the test that Dyroff has articulated from the Ninth Circuit, tools to facilitate communication.
Appreciate that, was it? Thank you so
Thank you,
much.
Honor.
Counsel for the state or counsels, are you gonna, oh, sorry, my apologies, I meant to go to, we're not dividing these up, we're going straight in. Go ahead, please.
Yes, we are reviewing a little bit of musical chairs, and again, I appreciate the court's accommodation in this. I wanted to address briefly, because I do want to give my colleagues some time to address the last part, but I wanted to address briefly points about the Valid Deceptive Trade Practices Act. Your Honor, under the statute, Meta is exempted from liability because it is a publisher engaged in the dissemination of information. The paragraph in the complaint, paragraph 37, says specifically messengers used to send messages and exchange photos, videos, stickers, audios, and files. That is publishing activity. The plain language of the statute exempts Meta under the Deceptive Trade Practices Act. The exemption applies whether the information is Meta's own or whether it is a third party's disseminated information, and the only exception to the exemption in the plain language of the statute is the words "without knowledge of its deceptive character." But again, the state doesn't allege that Meta made any kind of knowing misrepresentations of fact, and I'd like to get into that a little bit specifically with regards to the actual allegations as I go through this. But I want to set aside the exemption specifically, and also address a very important part of the Valid Deceptive Trade Practices Act that says that the act only applies to goods and services for sale and lease. Okay, so that statutory requirement is the threshold for any claim under the Deceptive Trade Practices Act. The state originally argued, hey, well, there's this catch-all provision that doesn't say the words goods and services. I think we addressed that in our briefing, that statutory construction that Nevada courts have applied says that in fact all of those subsections do require goods or services for sale or lease. The state agrees that Messenger doesn't charge money for its users. They agree with that. They actually say that in their complaint. They say in paragraph 39, Messenger does not charge money from its users for access. So again, the Nevada Deceptive Trade Practices Act doesn't cover just this use of a service, and that admission is dispositive. Now I want to put a pin in this, Your Honor, because I also did have a chance to review the transcript from the TikTok case recently, and I want to draw a distinction there. Because as I understood the TikTok case, your ruling in that case had to do with this provision on goods and services, and you pointed out that TikTok has a monetization component. It has these coins that are actually purchased, as I understand it, with actual currency, and then these coins are used on the application. Now that is a distinction that we do not have here in this Messenger case. The state has admitted in its complaint we do not charge money for its users for access. They say only that they're talking about some sort of personal information or data, but courts have rejected these arguments that just the transfer of personal information means that it's somehow a purchase or lease of the service. So I think, Your Honor, that is, first, it's a distinguishing characteristic from the previous cases you heard, but secondly, courts have said that this personal information transfer is not enough. It doesn't transform it into a good or service under our Deceptive Trade Practices Act. We had some more, I'll call them technical arguments under the act, and I'm mindful of my time, Your Honor, and again, I didn't want to steal all of my colleagues' time as well, and because I do want the opportunity to rebut the state's claims. So we had some more what I'll call technical arguments, and one of them is the standard for pleading fraud here in Nevada under 9B. The count 1 actually sounds in fraud. It's premised on alleged misrepresentations and omissions. It says that defendants willfully committed deceptive trade practices because of false representations. They say that in paragraph 463. It is black letter law here in Nevada that a claim alleging misrepresentations should be dismissed if it is not pled with the particularity required by those heightened standards of Rule 9B. We have these vague allegations in the complaint about Meta speaking to, I don't even know, various people, but there's no actual, when the statements were made, where, by whom. It just, there's statements like this in the complaint. Meta affirmatively misled the public, or Meta knowingly misrepresented to regulators and the public. There is not the same sort of specificity that our Nevada law requires. Now the state kind of pivots. They say, hey, we don't have to comply with 9B because there's these other cases that say we don't have to comply with 9B for a claim under the Nevada Deceptive Trade Practices Act. I just want to point out that the cases they cite do not say what they would like them to say. The Betzinger case that they cite actually talks about the standard of proof at trial, and it doesn't talk about the pleading standard. The Poole case that they cite doesn't talk about the pleading standard. It talks only about statutory construction of the word knowingly. And then they cite an unpublished order from this court's predecessor in the Benitez case. It was never, the case was actually dismissed, never went anywhere. They cite that as somehow proof that there is no need to file to allege claims of particularity. None of these cases apply. Certainly that Benitez case district court order is not the kind of authority they'd really like to see. It was a disputed order and the case was ultimately dismissed. When you break down the state's claims, they have sort of 5 categories that they claim are somehow actionable as deceptive practices. They first have these sort of what I'll call these safety claims, where they say things like in paragraph 23, Meta made material misrepresentations to develop trust among consumers, parents, and guardians that its social media platforms are a safe place for young users. Again, no specificity, no details. They say in paragraph 264, Meta has led reasonable consumers, parents, and guardians to believe its platforms, including Messenger, are a safer and less harmful platform than they truly are. Again, not specific, not stating a claim for deceptive trade practices. And then this one, which I'm not even sure how you can even evaluate it, it says I'm looking at paragraph 340, through public representations, Meta creates the impression that its platform, if particularity were just met by me creating an impression, I don't see how that actually could ever meet our standard, Judge. And these kinds of claims, other courts have called them sort of mere puffery, and have said that these puffery kind of vague claims that things are safe are just not enough to support a misrepresentation claim. Other categories that the state addresses are these selfie filters. But again, those allegations can't support a misrepresentation claim under the heightened pleading standards. The statements that they say about the selfie filters, they don't even say what information was omitted. They don't say that users would have acted any differently had they had information. They are very vague. They just say that Meta's decision-making behind Messenger's cosmetic selfie filters, illustrates the company's willingness to implement harmful platform features. Well, again, that doesn't say anything, and I was just reading from paragraph 3 or 9, that doesn't say anything about what was misrepresented, how, and it doesn't comply with the Brown versus Keller heightened pleading standard. Another category of statements that they have has to do with this time spent tool. And again, they don't say how statements about the time spent tool were inaccurate or misleading. They say Meta knew the time spent tool was delivered inaccurate metrics. Well, that is hardly anything more than just a conclusory statement. It doesn't say any sort of specificity that the rule requires. Also, the fourth category then, Your Honor, would be, there's some allegations in the complaint about these community standard enforcement reports, which everybody abbreviates as CSER. And then there's a comparison to this other acronym, the Bad Experiences and Encounters Framework. That's the acronym is BEEF, so BEEF. And what the state does there is they say, well, hey, these allegations about what BEEF is saying means that, you know, your community standards enforcement reports were wrong, but the BEEF, this Bad Experiences and Encounters Framework, is actually measuring what users are self-reporting. So that is a false equivalency to try to compare these two issues. And in fact, the state really sort of agrees with that. They say that the comparison of these two is a false equivalency. Well, that can't possibly establish then a misrepresentation or falsity. And then lastly, Your Honor, is statements to Congress. I mean, obviously, many of the statements that are made, these are alleged misrepresentations. They weren't made in any kind of consumer transaction. All they're made in testimony to Congress. I think that you know, that should be pretty obvious that those are barred because of the First Amendment. You can't base claims on congressional testimony. Unless you have any questions, Your Honor, I'd like to cede the remainder of my time now to my colleague, and then we want the opportunity for rebuttal.
I do not at this juncture. Thank you so much.
Thank you.
That's on.
You're good.
Okay.
We're good.
Right.
Yeah, no worries, yeah. Red means it's on, green means it's stopped.
Got it.
Welcome to the 8th.
Good morning, Your Honor, and may it please the court. David Sneed on behalf of Meta. I will briefly address the remainder of the claims that are at issue in this motion to dismiss. The first issue I wanted to address briefly was the question of the product liability claims, counts 3 and 4 of the state's complaint. Fundamentally, the argument is straightforward. Our position is that Messenger is not a product, and thus their claims do not fall under the product liability legal standard. And what we've done in our briefs is point to the Schuler case at 136 Nevada 447 to address the Nevada Court of Appeals way of approaching what constitutes product. And it was very clear, the Schuler case looked to the second restatement and looked at comment D of that second restatement for a group of things that would give an examples of what constitutes a product. It's an automobile, a tire, an airplane. Things like that are things that are tangible, that are more like what product liability was created, what legal framework was created to address. And courts have followed that line of authority and line of analysis to look at what are the features of the actual item at issue. Is it tangible? And are they like the things that the restatement has identified as things that qualify as products? Well, in response to our pointing to that analysis and explaining that Messenger does not qualify for it, and the reason Messenger does not qualify for it is because Messenger, like other social media services, is essentially intangible information, content, ideas. That's where the presumed and alleged issue and injuries are arising from. Ideas and content that's reflected on these services. So our argument is that Messenger can't qualify as a product for that reason. The state chose not to deal with Schuler, the restatement, section 402, comment D. In fact, their argument in their brief, pages 38 to 40, does not mention any Nevada precedent, does not mention the restatement, or address that analysis at all. Yet their complaint reflects the very thing that we argue is at issue. Their claims are based on intangible content. If you look at complaint, paragraph 242, it's about body image related content. Complaint, paragraph 357, self-harm related content. Complaint, paragraphs 360 to 66, bullying and harassing content. These are the basis for their claims, and they haven't identified or pointed to anything that would qualify as a product under Nevada law to be able to anchor their claims and get the benefit of a product liability legal framework that would apply to things that are products. Instead, the state's argument essentially boils down to three things in response to our Nevada case law and analysis. The Lemon case, which you've heard my colleague, Mr. Hester, address in relation to the Section 230 analysis. They point to Meta's terms of service in relation to Messenger, and they point to the deposition of Mr. Winters, the 30B6 deponent, for the purposes of jurisdictional discovery, to say that somehow the Messenger claims qualify under product liability law. None of them say that. Lemon itself is a case that addresses Section 230. And if we look at what Lemon, in the first page of the analysis, says it decides, it says it addresses whether the district court correctly dismissed that action when it concluded the CDA barred the parent's claims because it sought to treat Snap as a publisher or speaker. The question in that case, fundamentally, its holding and everything about the analysis in that case related to whether or not Section 230 applied, not this question of whether or not it is a product or not. So Lemon doesn't answer that question for them. Second, their terms of service. They cite no authority to say that a reference to the word product in the terms of service means that the legal definition, the legal conclusion that something is a product has been met. And courts in Nevada have said that Schuler case does explain that this is a legal conclusion. It's a matter of law for the court to analyze. And the state offers no authority for the purposes of parachuting in the terms of service to replace legal argument or legal authority to back up their argument that Messenger qualifies as a product. Third, Mr. Winter's testimony. Again, the same problem arises. These statements of legal conclusions in depositions do not have a dispositive effect, as reflected in the Bittler case that we referenced in our brief, but more generally, common sense says that someone using the term and using the word product in relation to the things they're working on cannot satisfy and cannot somehow fill in for the lack of legal authority to allow the court to reach a legal conclusion that something is or is not a product. So based on our arguments in our brief and what I put forward, the state's failure to respond to the Nevada case law that analyzes how to go about figuring out whether something is a product or not, we would argue that Messenger does not qualify as a product. I will turn now to the remainder arguments, and I'll be very brief about the next two. They're somewhat related. Count 5 is the negligence claim that the state has put forward, and our argument is that they have not alleged and identified a cognizable duty to support its negligence claim. That's the portion of the negligence claim that we're challenging. The parties cite several cases. I'll point the court to, as my colleague mentioned, the Dyroff case that specifically explained, and I'll quote, "No website can function if a duty of care was created when a website facilitates communication in a content-neutral fashion of its users' content." This case is the messenger cases we've talked about. The name of the app and what it does is reflected in what it does. Messenger. It allows third parties to communicate with each other. It facilitates communication. The state's response is again to stretch lemon, a case addressing Section 230, to try to parachute in some of the language that it uses around duty and say that somehow that provides the legal authority to say in Nevada there is a duty. Well, the case didn't address Nevada law. In fact, there was a question as to whether it's going to address Wisconsin or California law, and that wasn't resolved. So as an initial matter, it couldn't be a holding that this court would have to follow or look to. But more generally, as my colleague explained, the question of what this website does, facilitating communication, puts it in the world of Dyroff. And it's the same, it's the Ninth Circuit, and Lemon doesn't say anything about abrogating or taking away from the Dyroff decision. It's simply not addressing the question of what duty is applicable in a negligence claim in Nevada, and thus it's irrelevant to this court's analysis. Finally, across both the product liability and negligence claims, the state has failed to actually allege proximate cause sufficiently. And I won't spend a lot of time here. We've made this argument in our brief. The only response that we've seen from the state on the question of proximate cause is to say that proximate cause is a question of fact, and thus it must get past the motion to dismiss stage. Well, I submit that based on the Nevada law that we have put forward, there's case law, including the Payo decision from 2017, that references the question of proximate cause as being something that the court can make a judgment on as a matter of law if the alleged facts are so clearly deficient. And we'd say that they are sufficient here. And the reason for that is right in line with the arguments we've made on the other issues. Meta, through Messenger, has provided an app that allows for several settings and features, like endless scroll and notifications and likes. But what it hasn't done, what the state hasn't done, is reached through that and shown how Meta should be responsible and proximately caused any of the harms that are ultimately alleged in their complaint. And their failure to actually create each one of the links in their chain, even through allegations at this point, is dispositive of the notion. Is dispositive of the argument here on both the product liability and the negligence claims. The last thing I will say briefly on unjust enrichment is that the state states that Meta hasn't made any argument toward unjust enrichment, and that's incorrect. As my colleague argued, Section 230 and First Amendment, those encompassed in the unjust enrichment claim was encompassed in the challenge that we were making on those pieces. And so we have addressed each one of the claims in the state's complaint, and we submit that the court should dismiss it on these grounds and what's in the briefs. Thank you, Your Honor.
Okay, got a couple questions, if you don't mind.
Yes.
What is Messenger then? If it's not a product, but yet it has certain protections, right? What is it for purposes of our motion to dismiss?
Well, we submit that Messenger is a service that is provided by Meta to users that are looking to be able to exchange messages between each other. It is a service, and services, as reflected in the statement, are something distinct from products, which are known to be tangible.
Okay. So if it's services, right, what aspects of liability, I'm not asking you to create, cause of action against your own client, but realistically, what are you contending Messenger could be held accountable for if it's not a product, and yet everything's protected, right, under the First Amendment, et cetera? Does it get its own carve out where there's no liability under any type of claim? Because services, right, services can lead to negligence claims, right? Services can lead to a lot of different other cause of action. So can you kind of clarify where you're saying it fits within the realm of what it is?
Yes, I think because it is a service, it is not a product for the purposes of product liability claims. But product liability claims are not the only possible claims that could be brought against companies that create such services and provide them to the public. Like you mentioned, I think negligence is a good example. If the state were able to identify a duty of care that would be applicable, or if courts or a state legislature created a duty of care in reference to the activities that were here, then there could be a viable negligence claim. And we've seen in other cases, negligence claims that are brought against companies that provide a wide variety of services and things to the public. They could be able to be pursued through a claim via negligence if the duty element could be satisfied. All I'm saying in this instance is that the state has not alleged and argued and put forward a duty that's applicable here. But I'm not saying it's impossible for any service ever to be able to be pursued under a negligence framework. I do think it is true that they cannot be pursued, any service cannot be pursued under a product liability framework because courts have developed the strict liability framework for the purposes of pursuing manufactured products. And there's a boundary that has been set by courts as the law is developed. And that's changed over time. There have been times where privity was required and it was taken away. And I think that Schuler case gives a good rundown of the historical development of the product liability framework in Nevada specifically. But nothing in that case or any other case has said it could reach beyond things that are intangible. And I think shutting off product liability and shutting off this particular claim does not mean that this service would not be subject to any claim whatsoever.
So you're saying that content is not a product? Let's take a digital book, right? Is that a sort of, because in essence, right, part of the arguments to your 230 and your First Amendment claims, right, is that this is cultivated, created, right, and collated, right? And it has publishing features. That's why I use the digital book example, because the publishing analogy. So, are you saying that the challenge here for the court, and the reason why I'm going to pause in a second, kind of phrasing my question is, I'm trying to see kind of what box you're placing Messenger into legitimately. Is it just its services, so the only claim is potentially a negligence claim? If they can find a duty under your theory, right, for this case, and that there's no other ability to have any recourse, no way ruling on the merits, I'm just, where it's a pure, motion to dismiss pleading stage.
Well, I'd say a couple of things. The example that you've given in terms of a book is a good example in the sense that Meta is not the author of that book. If Meta was providing this book to the public as a service, it would be solely in the role of taking something a third party had created and allowing access to it from people who were users. And so that allowance of access, and for the reasons that is a publishing activity that is covered by the Section 230 arguments that we've made, it's covered by the First Amendment arguments that you've made. But I think at a base level, what you're struggling with a little bit is saying, okay, well, what can they be sued under? I do think that if Meta had made actual particularized statements or things, the Nevada trade practices and arguments that could be put forward is a legal framework that the state could pursue.
But that's not what your colleague says, right? She tells me that it's no product.
But I think the
It's
lack
nothing
of
for sale, right? It's nothing, I'm hearing what you're saying, and I appreciate alternative arguments, but I wouldn't even use the word struggle. What this court's trying to get further inquiry in order to make its well-reasoned decision was, I'm hearing a lot of excellent arguments. One of the challenges sometimes when you have three different people, right, is you're focusing on your arguments, but I'm hearing publishing on one hand, right, and cultivating content, and so therefore it has the control, so it's doing something, right, in order to have its content under the First Amendment and some parallels to the 230 claim. I'm hearing you're not selling or leasing anything, right, so, under the Deceptive Trade Practices Act, and then from here I'm hearing it's not a product, but yet it can't be a negligence claim because there's no duty, so I'm not sure what that, and I appreciate you representing, right? So you have a sage argument for each of your cause of action. But I don't think you're contending that there's not somehow Meta Messenger in this case is immune from all liability for all things because of the nature that it's Messenger, or maybe you are, and that's really what I'm trying to get clarification.
Well, let me put it like this. The legal frameworks that are at issue in this case, for various reasons, are not routes by which the legal background and the court case law allows claims to be able to be pursued for different reasons. I do think, like I said originally, general negligence claims, if legislatures and courts had decided that there were a different duty that can be put forward, it could develop, or there could be other statutes that legislatures could come up with to be able to say that there are legal liability. But what has been put forward in this case, the types of claims that have been put forward, are not available routes for the state to be able to pursue Messenger because of what its function is. And I think there's good reason for that. Ultimately, Messenger is not the creator of such content. It's providing publishing, and the federal legislators made a decision that this is not going to be a route that we're going to allow things to be able to be pursued.
I appreciate it. Thank you so very much. Everyone from Meta side had a chance?
Yes, Your Honor, thank you.
Okay. Thank you. The state.
Yes, Your Honor.
Now, I'm going to ask you, because of the time, whether or not you'd like, because I don't want to do anything in the middle of somebody's argument unless you want me to. I'm appreciative it is 10:10. You started.
You read my mind, Your Honor. That went a little longer than we anticipated, and so I think a short break might be appropriate.
Does that work for you all as well?
That's totally fine, Your Honor.
Perfect. Okay, see you back at 10:25.
Thank you.
Thank you, Your Honor.
Okay, we are back on the record. State of Nevada, would you like to set forth your position? Go ahead, please.
Yes, Your Honor. Good morning. Michael Gayan for the state of Nevada. I was considering going in a little different order, maybe starting where we left off, but I'm going to go through the issues in the order they were raised in the party's brief. Related to personal jurisdiction, the state is not attempting to establish general jurisdiction. I believe that's clear in the papers. But specific jurisdiction, and this was discussed back in March before we did the jurisdictional discovery in this case. I think it's interesting that Meta's now argued in its briefs and here today that the effects test doesn't apply at all. I think there was significant discussion about that. In March, again, at the motion to compel on May 10th, that was discussed extensively on the scope of discovery that was to be done. Now they're telling the court that the effects test doesn't apply at all. Regardless, the effects test is, I believe, potentially a more stringent test than the traditional test, and this is addressed in the Tripartite decision. So, Your Honor, I'm going to address it, but a little more briefly. I think it's covered in the papers, but if the court has questions, I'm happy to go over them. Your Honor, specifically, I know the court knows this, but the minimum contacts and the arising out of or relating to. I heard my colleague argue that it started with arising out of or relating to, and saying that because the state's claims don't arise out of or relate to, the court doesn't even need to consider Meta's contacts with the state of Nevada. I would submit that that is entirely backwards, that the analysis is to figure out what the contacts are first, and then do the state's claims arise out of them. I don't know how the court could do an arising out of or relating to analysis without looking at the contact. So, with respect to the elements that the state needs to establish, the first two, the minimum contacts and arising out of and or relating to, the state has the burden to make a prima facie showing. And prima facie, I know we don't talk about it. It seems like something lawyers and judges all just take for granted, but it means in Latin, at first sight. So the state does not need to prove conclusively that the state of Nevada and this court has jurisdiction over Meta at this point. We only need to make a prima facie showing. That is the Nevada Supreme Court precedent. And this evidence that the state has presented easily meets that burden. And Your Honor, the last part of the specific jurisdiction analysis of whether the traditional notions of fair play and substantial justice comport with this court exercising jurisdiction, that is Meta's burden to bear, and I don't know that I heard that discussed at all in court today. I know it's brief, but it certainly, at least from my recollection, was not discussed. And Meta has not met that burden to show that it would be unfair for this court to exercise jurisdiction over it for the state's claims in this case. Now, I mentioned briefly that the state presented substantial evidence. That's in the form of detailed allegations in the complaint, quoting dozens of internal meta documents that have now been unsealed, or at least the contents that are quoted in the state's complaint. It's also based on the jurisdictional discovery that the state has cited in its opposition, which remains sealed, and I will endeavor not to discuss in detail for the reasons we discussed earlier in the hearing. And it also includes other information that the state attached to the opposition. So, Your Honor, the court must accept all properly supported evidence, and Meta has not legitimately contested the evidence that the state has submitted. It's simply attacking it and claiming it is not enough. In terms of the contacts, looking at Meta's reply and its briefing in general, but specifically its reply, Meta's approach to minimum contacts is to divide and conquer and ask the court to look at each contact in isolation and say, well, this isn't enough, and that isn't enough, and this one's not enough, standing alone. But that's not the court's job. The court's job, under binding precedent, is to look at all of the contacts holistically. And there are many, and I'll go over them in a minute. But the court should not be persuaded to engage in Meta's divide and conquer strategy related to the contacts analysis. Your Honor, the Meta's approach to arising out of or relating to is also flawed because it is repeatedly far too narrow. It's essentially describing arising out of over and over again, but pretending that it is also looking at the related to portion of the analysis, which is discussed in the Ford Motor case, and I know the court knows that from prior briefing and argument, but Ford Motor, the facts there were car crashes in Montana and Minnesota, and the question was whether the claims in those car crash cases, claims against Ford, arose from or related to Ford's foreign-related contacts in Montana and Minnesota. And the crashes had nothing. Those cars weren't designed, manufactured, or even sold in Montana or Minnesota. And there is simply no causal requirement, and that's essentially what Meta is asking the court to do. And it's disguising that with its discussion, but essentially, if you boil down what Meta is asking the court to do in its arguments, they are asking for a causal connection between the many contacts they have, and the state's claims. One of the examples today was the teen forum that was held in Nevada. And they're saying, well, we're not being sued specifically for anything that was discussed at that teen forum. First of all, I'm not sure that's accurate. We don't even have discovery on what was discussed at the teen forum. But second, the related to aspect of the Ford Motor decision is far broader than Meta would have the court believe. Now, obviously, the Ford court did hold that there are some real limits to it. It's not unlimited. It's not like Walden and other cases where there's just simply no connection between any contacts and the claims. But here, the state's claims clearly relate to Meta's contacts that we've briefed, and I'll go over in an efficient way. But I believe they also arise out of, in many instances, the state's claims do from Meta's contact. Your Honor, I guess I'll jump into purposeful availment next, and as part of the minimum contacts analysis. Now, Meta, in its briefing and again here today, they are repeatedly asking this court to adopt some new standard that the Ninth Circuit en banc court vacated in the Briskin decision, that Meta has to do something different in Nevada than it does in every other state. That is simply not the law. There is no law binding on this court, which would be the Supreme Court of the United States interpreting the 14th Amendment for this purpose, or a Nevada Supreme Court case, saying that Meta has to try harder to contact Nevada than it tried to the other 49 states. And if you look at Meta's reply brief, there's a whole section, and they bold it in bullets, where Mr. Winters is talking. And we heard it today, so it's not, I'm not violating any ceiling, but that Meta tried, they had a specific focus on the United States to grow Messenger in the United States. Well, last time I checked, Nevada is one of the United States. And so there's no requirement, constitutional requirement, 14th Amendment requirement, that a defendant try harder in this forum than they tried in the other 49. The question is whether they tried. And they did. And the evidence definitely shows that Meta made a concerted effort to grow Messenger in Nevada and all other 49 states. So just because they didn't have a Nevada-specific policy or practice or strategy for Messenger is irrelevant. What matters is that they reached out to Nevada, formed contacts, and pushed to grow the product here. And I'll get to that in a bit. First, there is a physical presence. This is interesting, and we've briefed it, but Meta has effectively ignored that there's millions of Nevadans with the Messenger app downloaded and on their computers or their mobile devices, and that Meta has entered arguably into contracts with those users. But maybe those contracts are in question because today we heard there was no consideration given. So I don't know if any of those contracts are even enforceable if the court were to adopt Meta's argument that the users gave no consideration. So, Your Honor, the Supreme Court, what we have here in Nevada is that use of a telephone reaching into this state to contact a person here may be sufficient for purposeful availment. So, and that is citing the Coley case from the Nevada Supreme Court in 1995. So if someone sitting in a call center somewhere else in the world calling to Nevada and soliciting something from someone here would be sufficient, I cannot imagine how millions of app downloads and ongoing relationships between Meta and millions of Nevada users is not purposeful availment. The discovery we've done in the case shows that Meta knows it has millions of Nevada users of Messenger. It knows where they are. It knows what they're doing. It's harvesting all of their data and using it and exploiting it for commercial purposes. So to say that none of that is purposeful availment, I think, is a violation of Nevada law. It would be counter to the Coley decision and other cases we cited. Meta registered to do business in Nevada. I won't spend a lot of time on that. The Supreme Court here has said that standing alone, that's likely not enough. But again, this is not a standing alone proposition. It's certainly something that the court may consider in the overall context of its analysis. Meta's got many other intentional and substantial contacts with the state of Nevada that are outlined in our brief. I want to be careful because some of these are sealed, but many ads were served from Nevada-based advertisers to Messenger users, messengers. The ads on Messenger directed at Nevada generated substantial revenue for the company. Meta tracks its Messenger daily users by county, including in Nevada, and that's for purpose of more targeted advertising, its entire business model, and why it believes it's the better mousetrap in terms of online ads. Meta conducted the research with Nevada teens Meta has preload agreements with mobile carriers. And this was interesting. I don't want to go into too much detail here, but we didn't hear anything about that today, or the Meta Quest VR sets that were also available for sale. But there were untold numbers of physical devices, cell phones, VR headsets, other things with Messenger preloaded by design, by Meta, shipped to Nevada, sold, marketed to, and sold to Nevada consumers. So to say that is not purposeful availment is frankly absurd. And what Meta does in its briefing is it focuses on, well, the agreements with the mobile carriers, those weren't in Nevada. I mean, that is just such an overly narrow view of what's going on here. So the evidence clearly shows that Meta intended these devices to get to Nevada. And that's developed more in our briefing, but I'll move on due to sealing issues there. Similarly, Meta has come to Nevada to influence the Nevada legislature, and I won't go into the details there for similar reasons, but a number of the topics that Meta admits to involving itself in at that level relate to the very issues that are before this court in this case, including on the motion for preliminary injunction. So that is clearly relevant and intentional conduct. And again, the only way Meta tries to distance itself from that decision, purposeful decision, was that, well, there's no evidence that we're lobbying Nevada any different than we're lobbying the other 50 states or the federal government. But again, distinguishing is not a requirement. It's whether you were purposeful in your availment of this state. There's no comparing and measuring to all other 49 states. I mean, frankly, that's what courts would have to do. Okay, let's do jurisdictional discovery. Well, then let's do discovery on what Meta did in all 50 states, and let's measure it on some chart. That's not what we do. It's not what we just did in the state's jurisdictional discovery. That would be absurd. And frankly, if that is the standard, then the scope of jurisdictional discovery in every court across the country would be a lot broader. Your Honor, I'm going to skip forward. I didn't check what time I started. Was it around 10:25? Somewhere around there?
Exactly.
Okay, great, thank you. I just want to make sure I stay on track. Your Honor, another thing that's interesting, and we didn't hear, and actually we see in Meta's reply, Meta claims its Facebook and Instagram related contacts with the state of Nevada are irrelevant for today's motion. The state completely disagrees with that. I mean, I'm sure Your Honor recalls from all of the prior work and hearings in this case, including the motion to compel and the court's ruling on the non-messenger platform objection, is that Messenger, by design of Meta, was integrated in Facebook and Instagram, and the court ordered certain discovery related to Facebook and Instagram to the extent that it influenced Messenger either directly or indirectly in terms of trying to grow Messenger here. So we've had these discussions. I'm not sure why Meta thinks its Facebook and Instagram contacts are irrelevant. I believe the contacts are company-wide. What are the company's contacts with this state? Intentional, purposeful contacts. And then the court looks to see if the claims arise out of that. Our complaint is replete with references to Messenger and it being incorporated with the other platforms in order to leverage the success of those platforms to help grow Messenger, which was a huge focus. And this is in Meta's reply. It's a huge focus that they try to grow Messenger more. And I believe, we have not done discovery, but it's certainly possible that Meta integrated Messenger into its Facebook and Instagram platforms to help leverage the growth, and that affected Nevada users as well. Your Honor, I've already addressed the arising out of or relating to briefly. I don't want to spend too much more time on that, but Meta takes a very narrow view of that. The state has presented substantial evidence about all of the different touch points between the contacts and the claims in this case. It's in the briefing. I don't want to belabor the point, but I think from a 30,000-foot view, the sole reason Meta, at least as alleged in the complaint, Meta is an advertising business. So that's how they make their money. The sole reason that it designed and implemented intentionally these addictive design elements to drive compulsive use of children was to sell more ads and make more money. So to say that their millions of targeted ads here in Nevada have nothing to do with the claims related to these design elements is divorced from reality and the allegations in the lengthy complaint that the state has filed. I've already covered the downloads, the business license, the lobbying, preloads, and Quest VR. Those are all things to get Messenger into more Nevadans' hands and to get the ones that have it on their devices to use it more. That's why companies like Meta engage in those types of activities, is to get people to use their products more and more and attract new people to use their products. CES was the only other one. I'll just mention that that is, again, Meta wants the court to look at it in isolation. It's part of the overall piece. I don't know that CES standing alone is sufficient for the state's claims, but it's all part of the overall analysis. So, Your Honor, I'll move on to Section 230, unless the court has questions on the jurisdictional analysis or concerns with exercising jurisdiction. I would like an opportunity to address any concerns the court has, but
This court does need a clarification, because I'm not sure I'm hearing or reading the same thing on each of the parties' position as to the interplay between Facebook and Instagram with today's hearing. And I was reading the pleadings and went back and looked at you all's stipulations, right? So can you clarify to what extent you're saying that the court should be considering Instagram and Facebook, taking into account what the parties' agreement was, right, on them maintaining three separate, unique way that this was done to ensure that you had the separate case numbers and putting which case for which one, and the specific request of the parties to do different motions to dismiss on different days. I just need a clarity of what the state's position is. I'm gonna ask Meta the same thing when they have a chance for their reply.
yes, Your Honor. The state's position is that we are not asking Your Honor to decide Meta's motions to dismiss in the Facebook or Instagram cases today, or even to consider those motions. However, Meta's reply, I believe it potentially grew out of the state filing a consolidated opposition to all three motions to dismiss. The messenger reply that Meta filed made the statement that the Facebook and Instagram contacts are irrelevant for today's hearing. That's all I was addressing. I believe the contacts are relevant. If the court is concerned about considering those, then that's up to the court. But and I'm not asking to conflate the hearings or argue anything else. I'm just saying in terms of the contacts are company-wide. The Ford court looked at what were Ford's contacts with these states. They didn't just look narrowly. It was company-wide contacts and all of their operations in the state, and that's really the only point I'm trying to make.
Right, but unlike Ford, you all have a stipulation in this case, right? It's still what the parties want. That's the reason why the court was asking the question.
Yeah, the stipulation is for when the motions will be heard. I'm not asking to combine the hearings, have the court consider or rule on those motions. I'm just saying those facts for the jurisdictional analysis are also relevant to the overall analysis, whether the court has jurisdiction over Meta.
So for clarity, if presented in the actual opposition by the state, correct? For the purposes of this motion. are you asking the court to go look at other sets of pleadings filed in other documents for said quote, context analysis, or just to the extent like, part of the testimony was referencing, right, some bumping and things, if you want me to go back to March and May, right? And the motion
Nope.
to compel, so that's what I need clarity, because obviously, Meta might have a different position, so I need to hear the state's position to get us clarity on Meta's position.
Sure. The state is not asking the court to go look at anything else. The only thing I'm talking about are discussions on the state's consolidated opposition, and I don't know the document number, but it was filed
But that's the reason why
September
the court has to ask the question, because you did yours as a consolidated opposition without kind of pinpointing different pages for different ones of these motions. Similar to the question, remember, I asked on October 1 with regards to the motion to supplement. This court just wants to make sure that it is addressing everything it should be addressing, but not addressing things that I agree with the parties that you all asked the court not to address on this motion.
That's right. So what I'm discussing is on pages 11 to 15. And those are the Facebook and Instagram specific contacts. And that's all I'm referencing.
So then, are you asking the court then, when I hear the other motions, that I revisit those same pages for each of the three motions? You understand, one of the challenges when you file an omnibus, right, is for the court to be able to break out what applies when you want them to be heard 3 separate days, right, with 3 separate types of analyses. And I appreciate the overarching arguments might be similar. I would have to look this right, particularly in the context, whether or not you're saying this context should or should not be considered. So you're saying I should be considering everything from pages 11 through 14?
I believe they are relevant because Messenger is integrated into Facebook and Instagram.
Okay, appreciate it. Thank
So
you.
I would disagree with Meta that they're completely irrelevant for today's hearing. But even not considering those pages 11 to 15, there's more than sufficient evidence mustered by the state to meet its requirements to make a prima facie showing, not a conclusive showing.
Go ahead, please.
Okay, thank you, Your Honor.
We're gonna head to 2:30?
Yes, I'll go to 230. I'll try to be brief on that one, Your Honor. Section 230 simply does not apply. I mean, what we have here is Meta wants it both ways. It wants to say the First Amendment protects it because this is all first-party speech and it's Meta's expressive content or expression. And then it also wants to say Section 230 bars the state's claims because, well, no, really it's third-party speech and Meta is only a publisher by passing it along. I mean, Meta cannot have it both ways, and really I believe the state's briefing and the law says Meta can't have it either way under the facts, unique facts of what's going on here and the claims that are alleged and pled. Your Honor, there was some discussion, I'm not sure if it made it into the briefing because it's more recent, but Meta did cite Anderson versus TikTok, the district court opinion, but that has since been reversed, and I believe it may have come out before the state filed our opposition, but Anderson actually discusses Moody, and I know that there was some discussion on that today as well, and effectively the Anderson court's description of Moody says that quote, the court held that a platform's algorithm that reflects editorial judgment about compiling the third-party speech it wants is the platform's own expressive product and is therefore protected by the First Amendment. So then it later says, quote, given the Supreme Court's observations, it follows that compiling third-party speech amounts to first-party speech under Section 230. And the reason I mentioned that, Your Honor, here is that effectively the Moody decision from the United States Supreme Court puts all of everything we're talking about here today in this case, puts it under the First Amendment and not Section 230. And the state submits that Moody effectively calls into question all of this Section 230 case law that Meta has been citing. It certainly doesn't support the notion that the First Amendment protects Meta's conduct and commercial speech. But it does call into question whether Section 230 applies at all, because the Supreme Court has said this type of conduct falls into the First Amendment, not Section 230. Your Honor, I don't want to belabor Section 230. I mean, I have other comments, but I would ask if the court has any questions in particular, if the court has concerns about whether Section 230 applies to bar all of the state's claims as Meta contends.
Review on the Lemon application of 230 to the instant case.
Yeah.
You mentioned it in your brief, but you all have very different viewpoints on this application to the instant case.
Yes, I heard counsel say that Lemon was really just this speed filter, and so that's so different than what the state is alleging here. I mean, these are, the state disagrees with that characterization of Lemon or its claims, but Lemon, that decision, the Ninth Circuit said, that was a decision by Snap to make its product that way, to design Snapchat to function in that way. So Section 230 did not apply. That is exactly what we're talking about here today, and I think it's consistent with Moody. You have Meta deciding what features it will have on its platform. And the evidence cited throughout the complaint shows that Meta intentionally took advantage of kids' developing brains and the weaknesses and their inability to make good decisions for themselves and to moderate their own use of these social media products. That Meta took that science and figured out, how can we make features for our platform that will exploit those weaknesses in child's brains so that they will have compulsive use of our platform. And that is how Meta makes more money. More eyeballs and more time spent, and Meta tracks those metrics. Those are all Meta's choices, and that's how it ties back to 230. It is not simply Meta publishing somebody else's comment. The state is not suing Meta because some terrorist made a comment and someone else got hurt. That's not this case, not remotely. And the state expressly disclaims seeking any liability for content-related issues in its complaint. So Meta is trying to rewrite the state's complaint, both in Section 230 land and in the First Amendment, and frankly in every other section. They're trying to rewrite what the state has alleged so that they can hopefully fit the state's case into one of their defenses that they feel would either eliminate all liability, and I've heard the court's question, are you saying Meta is not liable at all for anything? And that was an interesting question, and it sounds like Meta is saying, yes, we can do whatever we want, and none of these claims are actionable. That's simply not borne out by what many other courts have done around the country. I know this court is required to do its own analysis, but certainly interesting to see what other courts have done with similar claims filed by states around the country or individuals who have been harmed. And the note from my colleague is a good point. Meta cannot and has not pointed to a single piece of third-party content that it would have to stop showing if we win this case. If the state prevails, there's no impact on the specific third-party content. Meta can continue to publish all of the third-party content it's publishing today.
Walk the court through what you mean by that.
Well, there's not a single post that would have to be taken down. That's my point. There's not a single post, comment, anything that Meta would have to change if the state prevailed and Meta was enjoined from using the addictive design elements for children. It would not have to take down a Nevada teen posting about what she did last night. That wouldn't have to change.
How about prospectively?
Prospectively,
Your request is also right. If you walk this through, right, it's gonna have some prospective aspects. I'm not going to take down a preliminary injunction, please don't head there. But how about prospective content?
I don't believe so, Your Honor, and my colleagues can correct me if I'm overstating that, but I don't believe prospectively
Fair
either.
is fair. I'm not trying to interrupt you right now, but I've been seeing post-its being written and walked up here, which is fine. But you also asked the same thing if you wanna pause or finish up your 2:30 and then other council wishes to jump in by fairness, you know.
Sure,
we'll
maybe
get
that
into
would be a more efficient way to do it, and Mr. Slade can just keep a list of anything that he wants to back clean up on, and then we'll give him the floor when I'm done. But, Your Honor asked some questions about end-to-end encryption. I'd be happy to address that, but I don't know that it's necessary. The Meta, and this was both, I believe the court had questions under multiple theories for end-to-end encryption, but end-to-end encryption, as the court knows, simply impacts whether Meta retains a copy or could provide the law enforcement the information. So there's, I don't know how that impacts anything that we're talking about here today, where that portion of the state's case would fail. Your Honor, in regards to the First Amendment portion, and I do have a number of sections left, and I want to keep moving, but Meta cites to Central Hudson Gas and Electric for this idea that the state cannot govern commercial speech in the way that the state is trying to do with this complaint, or that they're trying to make commercial speech sound different than what the state is alleging here. But interesting note, and I feel under the rules of professional conduct, I'm required to alert the court to this case, but it actually is a Nevada Supreme Court decision that cites Central Hudson, and I don't believe it was briefed by Meta or the state, but it's Irwin versus State, 111 Nevada 1535, 1995, and the pin site is 1541, and I believe it would control this issue, where it's specifically held, and this was in the context of deceptive telephone solicitations, but it's essentially the same concept here, and the court there said that the state may, quote, freely regulate, close quote, misleading commercial speech. And so I believe that decision controls the outcome here. This is commercial speech. All of this, anything that Meta is doing here is intended to drive business and profits for the bottom line. That is commercial activity in its most general sense, and the state can, through the Deceptive Trade Practices Act, regulate that sort of speech. And because of that, intermediate scrutiny applies, and for intermediate scrutiny, there's only a requirement of narrow tailoring so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. That's the U.S. Supreme Court Turner Broadcasting case.
Counselor, I'll pause you for a quick second, because you
Sure.
mentioned Irwin versus State.
Mhm.
Did you bring that to the attention of opposing counsel? Because you can appreciate why I might be asking that question, because maybe that case came up on or about September 24th in another case, right, that it wasn't briefed. So can I consider your analysis of Irwin versus State?
Well, I don't know that anyone on our side brought it to Meta's attention before right now. It sounds like maybe Ms. Peterson's reading transcripts from other proceedings, and so she may have been aware of it. But I believe under the rules of professional conduct, I do have an obligation, if I believe there's binding authority from the Supreme Court, to bring it to the court's attention really at any time. And so that's what I'm doing here. They're welcome to respond Whether the court considers it or not is up to the court, but I feel like since a lot of the briefing on this motion to dismiss is not necessarily binding on the court, a lot of the cases cited, I believe that one is, and I didn't want to omit it from the state's presentation.
Go ahead, please.
Your Honor, I've already addressed the Moody decision. Moody doesn't affect the analysis of this court for the First Amendment or the analysis of any of the other courts around the country considering similar claims by other states. And some of those are cited in footnotes in our briefing. I'm happy to address any questions the court has on First Amendment issues. Otherwise, I'd like to get into the deceptive trade practices next.
I do not have any further questions, thank you.
Okay, thank you, Your Honor. In terms of the Deceptive Trade Practices Act, Meta claims it's a protected publisher under the statute. They've got no case to support that. They're just citing the statute itself. And we've briefed that. I don't believe that has any application here. And specifically, that statute requires that the publisher reproduce the material without any knowledge of its deceptive character. Our complaint has more than 100 paragraphs talking about the deceptive nature of Meta's conduct and what it knew, and that it knew it was being deceptive, so I don't believe that exception applies at all. In terms of sale or exchange, statute NRS 598.0915 subpart 15 does not require sale, first of all. It applies whenever someone knowingly makes any other false representation in a transaction. And these are certainly transactions. Second, Meta ignores the statutory definition of sale that does not require the exchange of dollars. Ms. Peterson focused on the coins issue with TikTok, but that doesn't really even matter. Of course, it was one of the facts in that other case, but in this case, it's not required. The statute just requires the sale or attempt to sell any property or any consideration. So what do we have here? We have users' data that is being harvested and used in exchange for the use of the products, the platform. And that data is clearly very valuable in today's economy and how the world works. Meta's most recent annual report showed more than 23 billion in profits. That data is very valuable in the way that Meta uses it. So to say that there was no consideration given for the use of its messenger product is just frankly false. That consideration is a very broad concept. I'm sure the court recalls that from law school in many years since then. Your Honor, one thing that I also wanted to bring to the court's attention, Meta should be aware of it, but it didn't mention this, but Meta cited the Indiana court decision in the TikTok case about how that trial level court decided TikTok downloading and using it was not a transaction or whatever under Indiana's statute, Deceptive Trade Practices statute. But just a week ago today, on September 30th, the Indiana Court of Appeals actually reversed that decision and said that TikTok's business model of exchanging access to its content library for end user personal data is a consumer transaction under their consumer protection statute. So I believe the court should be aware of that. And the date of that decision was September 30th, 2024, but the Court of Appeals has reversed that. So to the extent Meta has relied on it, it is no longer good law. Whether it's certainly not binding on this court, that's a very differently worded consumer protection statute in the relevant language. But and then the state cited the R.J. Reynolds case from the Nevada Supreme Court here that under our Nevada Deceptive Trade Practices Act, a consumer doesn't even need to purchase or use the product to state a claim, as long as there's direct harm from the deceptive practices, and we've heard no real response to that. I also heard that the Betzinger, now I'm on to whether Rule 9B applies. Meta has not cited any binding precedent that says Rule 9B pleading standards apply to a Nevada Deceptive Trade Practices Act claim. And counsel tried to creatively argue that the Betzinger decision only says that the 9B standard applies for proof at trial. But and while that appears to be accurate, I can't imagine that the higher pleading standard would be required, but then the proof standard is lower. And I don't know if I said that right, but if the standard of proof at trial is not a higher standard for fraud, then neither is the pleading standard. Maybe that's a clearer way to say it. So I think it's nonsensical to imply from Betzinger that there's a higher 9B pleading standard, but a lower burden of proof later on when you get to trial. That's simply not the case. We also heard Meta's misrepresentations of fact are not actionable. I believe we've briefed that sufficiently. We have, I wrote down a note here, let me see if I can find where it is, but there's, from paragraphs 263 to 441, these are 30 pages of the state's complaint, go over Meta's material misrepresentations and omissions. And so even if Rule 9B did apply, I believe the state has satisfied that, but it doesn't apply. And the dozens of misrepresentations and omissions alleged in the state's complaint in those 30 pages and nearly 200 paragraphs of the complaint certainly lay out numerous actionable statements under our state's Deceptive Trade Practices Act. And the statutes to support that are NRS 598.091 sub 15, creates liability for knowingly making false representations in a transaction, and 598.0923 subpart 1 creates liability for failing to disclose a material fact in similar circumstances. So we've got many, many facts. It's briefed, it's in the complaint. I won't belabor the point. I know it's approaching lunch hour. In terms of, happy to answer any questions there, and maybe I'll take a pause.
Same question I asked Meta, right? What is the state considering messenger? I've heard the term from your end, a platform, right? You've also used the term service. You've also used a variety of other terms. So what are you considering messenger?
Messenger is a product. It is, and I was about to get into that. I'll cover it in more detail, but
That's fine, I can pause my question until you finish.
sure.
Okay.
I was going to get there, and I appreciate that's an important question that the court needs to ask and consider. The first thing I will say before I get into the evidence and the allegations on this issue is that we are here on a 12b-5 standard. Now, a while ago I transitioned from 12b-2 to 12b-5, so everything after personal jurisdiction is under Buzz Stew, and the court would have to find and decide as a matter of law that there is no set of facts possible that the state could show to support its claim. And the state has clearly alleged that Messenger is a product, and I'll go through some of our allegations in our complaint. Meta has called itself a product. Now it's saying that what it says doesn't matter, that it's a legal determination, which might be true, maybe. But it's certainly a legal determination informed by some facts. And we have pled sufficiently, and there should be discovery, and then the court will have facts, and can ultimately make the decision on whether the product liability causes of action go to trial or not. But to do it in a vacuum under the Buzz-Stu standard, I believe would be inappropriate, at least on the unique facts of this case and what Meta has said and what many others have said about Meta's product. So just going to the complaint itself, this is paragraph 52. Meta's terms of use repeatedly call Messenger and Facebook products. We have in paragraph 6 of the state's complaint, the U.S. Surgeon General calling social media platforms products, and this is, quote, "You have some of the best designers and product developers in the world who have designed these products to make sure people are maximizing the amount of time they spend on these platforms. And if we tell a child, use the force of your willpower to control how much time you're spending, you're pitting a child against the world's greatest product designers." That's the U.S. Surgeon General alleged in the complaint, okay? These are product designers who are being employed by some of the largest companies in the world to develop products that will addict Nevada's children. That's what we're talking about. Now, we also have, this is in the complaint, paragraph 170. Ms. Antigone Davis, who the court has met and heard from, she testified before Congress in 2021 and admitted Meta worked with experts to, quote, "help inform our product," close quote. Paragraph 170. Then you also have in paragraph 174, Meta employs a vice president of product design. That is the person's title. Excuse me, I think the full title, as alleged in the complaint, is VP of Product Design and Responsible Innovation. I don't want to misrepresent that. Then you have Meta's former, this is paragraphs 21 and 384 in the complaint. Meta's former Director of Integrity, Arturo Bahar, provided testimony calling Meta's SMPs, quote, products, repeatedly calling them products. You have Meta's internal documents cited throughout the state's complaint and quoted, discussing the Messenger and Facebook and Instagram platforms as products in different ways. They use, quote, product research. They use product strategy, product usage, and other product references. And those are in paragraphs 97, 108, 109, 120, 237, 279, 282, 289, 292, 293, 294, 313, 395, and 396. Those are all direct quotes from Meta's own documents calling their platforms products. Interestingly, the court also heard on March 21st of this year from Mr. Ime Archibald. He testified. He was asked by Meta's counsel to introduce himself to Your Honor. And he said, quote, "Yeah, my name is Ime Archibald. I am the Vice President of Product Management at Meta, and also the head of product of Messenger at Meta," close quote. And that's the 321 transcript at page 40, lines 4 to 8. You also have, and this is in the state's opposition, Mr. Winters, Meta's Rule 30b-6 witness. He called Messenger a product close to 40 times in his deposition. And he called Meta's suite of SMPs or platforms, Facebook, Instagram, Messenger, WhatsApp, products, another 30 plus times. So you have scores of references in Meta's Rule 30b-6 witness testimony, which I believe is binding on the company, and the court can do with it what it likes. But you have Mr. Winters under oath calling Messenger a product dozens of times. So with all of that information and all of those admissions and discussions by Meta coming from Meta's own mouth, or the mouths of its employees, I believe the state's allegation that Messenger is a product is certainly plausible at this stage in the proceeding and under the Buzz-Stu standard, the court has enough in front of it to allow those claims to go forward and discovery to go forward. And I'm sure there will be fact discovery, maybe expert discovery, and the court might have more information before it down the road, before we get to trial on this issue, and the court can make an ultimate determination on whether that issue goes to the jury or not on these product liability claims. But I believe, based on the Rule 8 pleading standard and the Rule 12b-5 dismissal standard, and what I've just gone through on what the state has alleged and the evidence before the court, that there could be a set of facts out there that would support Messenger being considered a product under the law, and that dismissal at this stage would not be appropriate. So hopefully that answers the court's question on what the state considers Messenger to be, but it's certainly downloaded and installed on millions of devices here in the state and being used in the fashion of a product as well. That is all information before the court.
Then do have to ask the follow-up question, right? Because products liability, strict liability standard. So you're saying there's strict liability for Messenger here in the state of Nevada?
In terms of defective design and failure to warn, yes.
Okay, go ahead, please.
Yep. Your Honor, now I'll move on to negligence and the alleged lack of a duty. I think we've briefed it. Nevada law recognizes the generally applicable duty of reasonable care by anyone doing anything. So paragraph 516 of the complaint, the state has alleged that defendants had and continue to have a duty to exercise reasonable care in designing, implementing, maintaining, and otherwise introducing Messenger into the stream of commerce. Paragraph 517, this duty of reasonable care extends to young users in the state of Nevada. And I know there's discussion and briefing on the Lemon decision and whether it touched on the product liability claims, but there's no dispute that the Lemon court's reversal allowed product liability claims to proceed below. And there's some discussion of manufacturers' duties, and that's where Lemon comes into the duty issue. In terms of proximate causation, again, 12b-5, buzz stew, and I heard Mr. Sneed argue that this shouldn't be a question of fact because it's so obvious on the face. I mean, the court has hundreds, thousands of cases it's presided over the years. I'm not sure that this one is an obvious one, but I'm sure Your Honor has seen many ones that are maybe closer to the obvious line about there can be no proximate causation. But in this case, with the extensive details, factual details alleged, and the significant harms alleged by the state that are going to be the subject of expert testimony, I do not believe it would be appropriate for the court to wade into and say here today that as a matter of law, there's no causation between anything that Meta is alleged to have done by the state and any of the alleged harms. That is a real stretch, and there's plenty of facts to support the state's allegations, and that is a question of fact for down the road. But just for the record, and so it's clear to the court, paragraph 520 of the complaint, the state does allege that Meta's conduct caused the harms that are being alleged as well. And Your Honor, I just wanted to brief, I know it hasn't come up in Meta's briefing on standing, but the state does allege in paragraph 28 that Attorney General Ford is acting pursuant to his authority under the various statutes here. And one is NRS 228-310 that creates the Bureau of Consumer Protection within the Office of the Attorney General and establishes the head of that bureau as the consumer advocate. Then 228-380 authorizes the consumer advocate to exercise the power of the Attorney General in areas of consumer protection. 228-390, subpart 1A, authorizes the consumer advocate and gives him or her sole discretion to represent or refrain from representing the public interest and any class of customers in any proceeding. And in that statute, public interest is actually a defined term, and is defined to include the interests or rights of the state of Nevada and of the residents of this state, or a broad class of those residents which arise from the Constitution, court decisions, and statutes of this state and of the United States, and from the common law. So, believe, just because standing is sometimes viewed as the burden of the plaintiff to show that they have, I didn't want that to go unmentioned. It is alleged in the complaint, the statutory scheme that I just went over, and then also NRS 598.0963 subpart 3 also expressly authorizes the Attorney General to file this suit and prosecute these claims. So I believe it's entirely appropriate for this case to proceed. Meta's motion to dismiss should be denied in its entirety. I'd be happy to answer any other questions the court has before seeing if Mr. Slade has anything he wants to clean up.
Let's circle back to the 598 claim.
Sure.
So the 598.0915, were you saying subpart 5 was your basis?
Subpart 15, I believe. And I don't have the statute pulled up in front of me, but my notes from the briefing, I believe it's .0915 sub 15.
So it's the knowingly in a transaction.
That's right.
Okay, that's okay. Thank you.
And I guess I'll see if Mr. Slade has, looks like the answer is yes. Maybe a minute.